Well, welcome everyone to the Anatomy of a Contract, Perspectives and Pitfalls in Negotiating Essential Provisions. My name is Jenny Smiley, and I'm going to get us started today and introduce our panel. This course has been approved for 1 hour of CLE credit. The course number that you enter into the State Bar website is 174-085-773. So first up on our panel is Katherine Gnadinger. She is formerly a senior attorney at Bell Helicopter, and now she is an attorney for Microsoft, supporting US commercial sales and licensing. Next up is Ashley Deweese. She is a real estate associate and deal maker at Barnes & Thornburg, LLP. And last, we have Bryan Henderson, who's an M&A and corporate partner at Baker Botts. So take it away, Katherine.
Okay. So today we're going to try to get through quite a few topics that have to do with transactional work and contracting. Please feel free to add any questions that you have in the Q&A box. The panelists who aren't speaking, we'll try to monitor it and answer as best as we can. And hopefully we can cover everything. Our contact information was on a previous slide. We're all open if you want to email questions afterwards, or if there's any kind of questions you think may be longer-winded that we may not have time for. I think all three of us are open to discussions later. So feel free to use the Q&A box and feel free to email or call. So we're going to start off with non-disclosure agreements and kind of get a little basic here. So what is the purpose of a non-disclosure agreement? Most often it's to govern the protection of confidential information. You'll see some NDAs that are also used to govern the method of exchanging of information, but they are not typically used to require the sharing of information. They may govern what you protect and how you exchange it, but they don't necessarily require you to exchange it. So the first thing you want to look at when you're looking at a non-disclosure agreement is, what are you protecting? You need to define your confidential information. This can include any non-public data, including personal identifying information. It's not just limited to trade secrets. So I work a lot, with companies, and so we're very concerned about trade secrets, but you use NDAs in various different aspects in your time as a lawyer, and even just as a person living in the US, you may need to sign them for various reasons. And so determining what that confidential information is important. There are kind of two frames of thought when you're looking at NDAs. Either everything you exchange is confidential, or only the data that is marked as confidential. So some pros for everything being confidential is that you're not worried about someone seeing something that's unmarked, or sending something that's unmarked that should be protected and isn't because there's no marking. But the con there is that you could end up protecting far more than is really necessary to protect. So a pro for marking is that you can control the data. You have a clear understanding of who owns what data and what should be protected. But one of the cons of that is that you may miss markings, or if you are disclosing confidential information orally or visually, that data may not be protected if your terms aren't clear. That being said, when you define confidential information, you're also going to have to define what is not confidential information. Very commonly, things like data that's already public, data that's shared with a third party who had no restrictions on its dissemination, may not be considered confidential information. Additionally, some NDAs may specifically exclude IP or technical data because if you don't want to get into ownership of that data, you don't really want to exchange it up front. You may leave that for a later contracting vehicle and specify clearly that none should be shared and it's not considered confidential. The next thing you have to ask is, what is the purpose of the agreement? This can be vague, any collaboration between the parties, or it can be very specific. The purpose of this NDA is for collaboration between the parties on XYZ project. It can also limit what kind of information will be protected. So you would say only information shared for XYZ purpose will be protected under this agreement. And then finally, it can limit what the information will be used for. So information shared under this agreement may only be used to facilitate purpose XYZ and for no other purpose. All of this depends on the relationship between the parties, how long the relationship is going to last, and what business that you have. If it's a short-term NDA, if it's something that is supposed to govern the protection of information for years and years, is really going to depend on the specifics of your situation. So the next question is, you have to define the parties. Who are the parties? Who can they share with? And then you'll look at non-solicitations. So when you're looking at who are the parties, you need to be specifics. Are affiliates included? If you're talking companies, is my sister company included? Is my parent company? Is my subsidiary? If the party you're negotiating against is trying to add affiliates, do you know who the affiliates are? I come from a previous company whose also I was in aviation, and we had sister companies in aviation. So when we contracted with third parties and created NDAs, they didn't want our affiliates to be a party as well. You also need to be specific about which of the party, is all the employees of a party covered? So if it's a company, is everyone who works for them covered, or are these specific individuals that are covered by the NDA? And then finally, who can the party share with? What third parties are allowed to view this information? What third party can you give confidential information to, even if they're not a party to the NDA? So if your affiliates aren't a party to the NDA, can they be shared with under a third party sharing portion of this? Is there data that's been requested by subpoena of the government, whether state, local, or federal? And if there is, do you want notice if those subpoenas are issued? There's also state, local, and federal governments that require information be shared with them if you're going to enter an acquisition contract with them. So for instance, in Canada, the Canadian government requires certain information be shared about suppliers. Most companies will have non-disclosure agreements with their suppliers, but they'll still be required to share some of that information with the Canadian government. And then internally, is this information to be shared with anyone? Does it need to be shared internally in your organization only with those with the need to know purpose? Sometimes this is important, sometimes it's not really a consideration, but if it is important, or if it is in the language that you're presented by someone else, you need to make sure you understand what that means and who you can share with, even within your own organization. And then I'm going to hand it over to Bryan to talk about non-solicitation.
Okay, great. So there, one other point on who the parties can share with, just a couple things there. Katherine mentioned that sometimes you want to share with affiliates and sometimes you don't. In the transactional context, one area that we always look for is if a private equity fund is involved, they'll often have employees of the private equity fund who are really kind of affiliates. You don't want to share with all of a private equity fund's portfolio companies, and B, the private equity fund will have an employee who's like a director on one portfolio company board and also on another portfolio company board. So you have to have special provisions in the NDA to address specifically those dual hat employees. And usually what would be done is you'd allow them you would deem the other portfolio companies not to have the information, but specifically prohibit that employee from using any of that information for one of the other portfolio companies. And that's particularly important in a transactional context where you may have a portfolio company, have a PE fund looking to buy a target company that is in a similar sector as a portfolio company. So you want to be really, really careful with that and think about how to limit the use of information. Also in the transactional context, we'll often see non-solicitation provisions, and those are sometimes pretty closely negotiated. Should you not be able to solicit any employee of the target company, or just the employees that you had contact with? And then how long is also something that there's really some variation on. Sometimes, most often, I think it's usually a year. Obviously, if you're trying to sell a company, you may want to make that longer. Sometimes folks ask for a couple years, and again, usually in the competitive context, that's particularly sensitive. see if I can get it to. Well, I don't think. There we go. Thank you. I think I've got control. Sorry about that, guys. Moving on to term and termination. You always want to think about how long the agreement will last. Occasionally, that is short if you've got a particular piece of, a particular meeting or something that you want to cover. Most of the time in a transactional context, it's a year to 2 years. Sometimes you'll have the term of the agreement ends, but there's still an obligation to keep information confidential. For instance, if you retain any information, your obligations would continue for a period of time. Sometimes that is cabined off, usually to some period of years, on the theory that the information goes stale at some point. If you're dealing with trade secrets, we usually try to make sure that those are protected for as long as those are protected under the law. Parties most often cannot terminate an agreement early, just because you don't want the goal. Your goal as someone providing information to another party is to really ensure that you have control of that information, and so you often have a return or destruction provision that says at your request, the receiving party will either return or destroy all the information, and usually provide a certificate to the effect that they have done so. Yep. So we'll move on. That's the NDA section. We'll move on to representations and warranties. And Ashley will talk a little bit about specific drafting points, but before we get there, we wanted to just cover the basics about what functions reps provide. And so they really provide, there's a diligence function that occurs before signing. There's a termination function that occurs before closing, and also they inform whether or not a buyer has to close a transaction. And finally, there's allocation of risk, and that really goes to usually in a private M&A type situation, or some of the contracts that Ashley will talk about, there are indemnity provisions, and the reps really help you allocate risk. So you're probably familiar with them. I'm not sure who has control. It says I am, but I can't make it move. So there's different. There are different. We skipped over, but there are basically different categories of reps. Fundamental reps are reps that you would just expect absolutely to be true, such as you own all of the shares that you're selling. Sometimes there's special reps for tax and environmental and IP, and then everything else. Usually dealing with everything from the finances of a company to property they own, and really there's probably a list of 20 reps you'll see. So the way that an agreement usually works is you'll have a very unqualified rep. You'll say, we own all of the, we have good title to all of our property. And so we thought it might be useful to show a few examples of disclosure schedules. So disclosure schedule is something that accompanies an acquisition agreement and provides a list of exceptions to representation. So you may have a representation that says, we have all title to, we have good title to all the property. And so there's an example here that is from an actual disclosure schedule that says, there's a cloud on title with respect to the ownership of the property referenced in item 5 above, and a quiet title action is needed to resolve the ownership to this portion of the property. And so it's really important here that lawyers dig in and ask questions and look for ambiguity, because it can really come back to haunt you on the allocation of risk portion. If you didn't ask questions on this disclosure, for instance, what if that's a $10 million problem on the quiet title issue? that'd cause a real problem for your client after they acquired a property, assuming you're representing a buyer. If you're representing a seller, of course, perhaps ambiguity is your friend, and so the example down below on the bottom is against a rep that you own all of the permits necessary to operate the assets, and there's a road that abuts one of the assets that says the company has not obtained all necessary rights to use the road. So if you're representing the seller, that's helpful. Perhaps you don't have to list all the rights they don't have, because you may not have time to obtain those before trying to close a deal. But the buyer should definitely be asking questions to find out if those are material rights that need to be obtained before you sign or close a deal. Of course, you want to do it before signing if you can. Another function of reps is they have an impact on whether or not you have an obligation to close a deal. So often acquisitions are done in a two-stage process. You sign and then close. So you may sign a deal and then have a period of time before closing that you go out and obtain necessary approvals, such as regulatory approvals, HSR approvals, maybe the Public Utility Commission of Texas, lots of different things they do. Sometimes you just have a slight gap so you can get organized. Now, when you sign a deal, you're of course saying that your reps are true at the time that you sign. But if you're the buyer of a company, you want to make sure that those are true at the time you have to close. If you're the seller, you really want to make sure that the deal will close, and you don't, for instance, announce a transaction to the market and then not be able to close. So that most often reps are brought down to the standard of saying that there's been no material adverse effect, and so that's a very seller favorable standard, because what is an MAE? It's a very, very high standard. I think the Delaware courts have found approximately one MAE ever, and there were some pretty extenuating circumstances in that case that showed that the seller was committing fraud, and so or at least had indications of that. So I think that we may have, and so MAEs are also used sometimes as qualifiers to reps. And so you'll say, except as would not reasonably likely to have a material adverse effect, sellers complied with all laws. Now, it's obviously, given the standard that we just talked about, not a very fulsome rep, but you may, for purposes of indemnity, which Ashley will talk about later, have a materiality scrape and essentially read out the materiality qualifiers, including MAE qualifiers, for purposes of allocating risk. And we just have a few examples here of the language you might ask for if you're representing a buyer or a seller.
My turn. Hi, everyone. Good afternoon. As Jenny mentioned, I'm Ashley Deweese. I'm at Barnes & Thornburg here in Dallas, a real estate attorney. So that's the bulk of my experience. I also have experience with corporate drafting and things like that. All kind of goes together. So to kind of piggyback off of what Bryan's been saying, another thing that you want to determine as you're negotiating these representations and warranties is how to create less risk for your client, and kind of decrease the potential for any foot faulting by the other party that you said this, but you didn't actually, live up to this standard. And so here we call them qualifiers. So there's various qualifiers that you can use to serve as that function. So it's important, kind of like Bryan said, to really think about how do these representations affect not only your decision to sign that contract, but also your, once you close, and what's your risk at that point. And so it's really important. I think the representations, you need to get them right, and you need to make sure that you create the least risk for your client when you're doing this. So For materiality, the goal is that you want to avoid being held to this 100% certain standard. So we use an example here, the financial statements are fairly present in all material respects, the financial condition of the business, or seller has obtained and is in material compliance with all environmental permits. Other examples I see, the property is in material compliance with all applicable laws, all of the documents that we've provided. So in a real estate contract and, mergers and acquisitions, you will get basically a document dump at the beginning to go through, all of the files that affect that company or that property. And so, while most of the time seller won't say, everything's true and accurate, they'll say, to our knowledge, they're true and accurate in all material respects. That's something you'll see very frequently. And then another materiality example that I see is, that there are no material non-monetary defaults. So again, if you're a party to a contract, you may not, have satisfied every little standard, but as long as there's no material default, that's really all a buyer wants to know anyways. Next, we move to knowledge qualifiers. So for knowledge qualifiers, first and foremost, what I look for is, have we stated that it is to that party's current actual knowledge? For those of you who have gone to law school or know anything about this, if you don't state that, then you could be held to have constructive knowledge of something, which means that you should have known something by, pursuant to whatever position you hold with the company or things like that. And so that's a way to limit the knowledge qualifier, or you may see to the best of seller's knowledge or something like that. And that also creates a higher standard for them. Other times, in addition to that, we will specify the parties to whom the knowledge is actually imputed on. So for a seller, you want to say, Ashley Deweese is, so seller's knowledge means the knowledge of Ashley Deweese. And a lot of times I will actually make them say, and Ashley Deweese is the party with the most knowledge of the property or the most knowledge of the business. Or they're in charge of the daily affairs of running the property or something like that, to kind of restate what their position is and to make that party back up who they are and that they are the person with the most knowledge. So we don't have Joe Schmo that's down in the basement getting these knowledge qualifiers who shouldn't know anything anyway. Sometimes in real estate deals, it's the asset manager or the property manager. With other transactions, it's the principals of the business or the joint venture or something like that. And again, if you don't specify a person, then sometimes the courts will impute knowledge to a larger pool of people than you intended. And so some employee that has knowledge of an email that says that you defaulted under this contract who didn't share that with anybody, you don't want their knowledge to be imputed against the seller, because then the other party could have a claim against you for that. And then one last thing on knowledge qualifiers is the duty to investigate or to inquire. And so typically we will carve that out and say, Ashley Deweese is a knowledge party, but she has no duty to investigate or inquire, because again, if you have hundreds of documents that affect this property, I'm not going to be held to know every single little word, every single provision. It's, what should I know in the position that I'm in? And so that's one other thing. And then something that's not in the slides, another qualifier that is important to note is written notice. So a lot of times you'll see, the standard provision in the PSA says there are no violations of law. But as a seller, you want to say we have not received written notice from the governmental authorities that we're in violation of any laws, or written notice that we're in default under a contract, because again, that just kind of limits the knowledge and limits the representation to kind of safeguard your client. So then we look at time periods. So the examples here again, the financial statements are based on the books and records as of the respective dates that they were prepared. And then further it goes on to say, and the results of the operations for the periods indicated, so that you're really limiting the scope of that representation and the time periods for which they matter. Generally in my role, we will say, certain certain non-fundamental representations, you will say, as of the effective date, this is the status quo. Or as of the closing date, this is the status quo. And without limiting it to as of the effective date, it kind of opens up this whole slew of, well, when were you talking about? Maybe we're talking about 5 years ago and that wasn't true. And for some, faulting counterparty, you don't want to get in that scenario. So it's really important to qualify time periods where you can. And to Bryan's point, a lot of times, if you enter into a contract, you want to make sure that not only is there no litigation affecting the property as of the effective date, but also as of the closing date. So once you take title, you want to make sure that during that 30 or 90-day period during which you were under contract, that those reps haven't changed. And so frequently we will do just a separate bring down certificate at the closing where the seller says, all of the reps in that section are true. They haven't changed. Or if they have, this is how they've changed. And that way all the parties are on the same page. And then lastly, on the reps and warranties, typically if I represent a buyer, I want the seller to give a net worth covenant, because a lot of times we create these SPEs, it's called a special purpose entity, that was solely formed to hold the property. And so once they sell the property, they get the money from the deal and then they distribute that to all of their members, and then there's no liquidity in that entity. And so if I, as the buyer, had a post-closing claim, I want to make sure that seller has at least, $1 million left to its name or something like that, so they could satisfy any post-closing breach of contract or indemnification claims that I would bring. And so that's something that's important to also look up. And then finally, what Bryan kind of said, survival periods are really important. You want to limit the time during which your client could be exposed to a breach of representation claim. So for the more important reps, like, there are no environmental issues, we want those to last as long as possible, because the claim may not arise until far after closing. And so typically in the transactional world, you'll see anywhere from 6 months after closing to 2 years after closing, just depending on the leverage of each party and things like that. So I will turn it back over to Bryan to go through different schedules and disclosures and exhibits.
Sure. So we won't spend too long on this, because we spent a bit of time on disclosure schedules earlier, but just to reiterate, the schedules are usually attached to the agreement or delivered with the agreement when you sign it, and really serve two purposes. One is the disclosure purpose that we talked about earlier, which are really the exception purpose. That is, they're disclosing exceptions to certain representations. There's also sometimes just what I would call informational disclosure, and that really helps on the diligence end. So you may have just a listing of all real property leases, for instance, that a seller has, and so there may be, all of the leases are listed in this schedule, and then you may have a rep that says, all of these leases are in full force and effect. There's no default, and so if there was any default under the lease, you'd have to schedule that separately. In the M&A world, there are some, you often negotiate whether or not you can update schedules between signing and closing. Generally buyers don't want schedules to be updated, because it will affect the allocation of risk. If as I talked about earlier, you have that really high bar to closing that says as long as there's no MAE, you have to close. Well, what if something happens between signing and closing that isn't an MAE, but the seller actually has the right to update the disclosure schedule? Well, that means that when you get to indemnity, that if remember there's something in the disclosure schedule, there's no breach of the representation, and so when you get to indemnity, there's no right for the buyer to have indemnity for something. And the idea is that really what happens most often before signing, or so before closing, should be kind of the seller's responsibility. So that's usually market. There's very rarely a right to update disclosure schedules. Occasionally you'll find some if you have a hard time, for instance, getting everything done before signing, and it's things that aren't necessarily material. I've had deals where you have the ability to update lots and lots of lists of easements. If you're trying to track things down at the time you sign, you may want to have the ability to do that between signing and closing without creating issues under the risk allocation. So secondly, we also attach exhibits. Lots of agreements obviously have different kinds of exhibits. Sometimes you just attach your boilerplate documents, like a FERPTA certificate. Often you don't, just because those are easy and not typically controversial. Real estate documents you will want to attach to make sure that everyone agrees on the form. And Ashley could probably speak to that better than I can, but you do need to work with the title company, work with your real estate lawyers, and make sure that you have the proper conveyance docs. You also have just forms of ancillary agreements. So again, if you're signing at one date and closing an agreement later, you may need to enter into for instance, a transition services agreement. And so you may agree on the form of that agreement at the time you sign, attach it to the back of the purchase agreement, and say at closing, everyone will deliver a signature page, which will make that a fully effective agreement. And it's interesting. Sometimes the transition services agreement, the form itself is usually not too controversial. They're fairly straightforward. Put most of the risk on the recipient of transition services, because the provider, who's usually the seller, doesn't in most market contexts take on risk under that contract. They just be like a third-party service provider and maybe have risk for, say, negligence or gross negligence, or just utter failure to provide the services. But other than that, not terribly high standards of service, although that can be negotiated. But they often take a long time to negotiate, especially if you're dealing with some kind of carve-out transaction where you're taking one business out of a larger business and selling that. It takes a long time to make sure that the buyer can keep the lights on, and that's something that's really important to them. And so I've had deals where it takes longer to negotiate the TSA than it does to negotiate the deal agreement itself. And you also want to think about how what your language is around agreements. Obviously, if you have an exhibit that is eventually signed, it's enforceable. But just make sure you're thinking about incorporating the various exhibits into the document. Usually, that's covered in boilerplate, but you want to read it carefully and make sure that it's clear that your schedules, for instance, are considered a part of your agreement. So.
Okay. Now we'll move on to indemnification, and please forgive me if I stutter over this word a few times. It's a hard one. So indemnification is one of the most misunderstood provisions in a contract, and I think most baby lawyers it's just very hard to grasp. But once you kind of understand the ins and outs, it's really not that hard. But you could create high unintended exposure for your client if it is drafted too broadly in the contract, where you throw in the kitchen sink and you have to indemnify for anything and everything. To me, the indemnification provisions come second after what does the damages and remedies provisions say, and then after that I look to indemnification, because it's basically another form of how can we hold the other party liable. So this is another mechanism to transfer and allocate risk to the party that should hold it. One of the most widely cited cases is Dresser, and it basically says it's an assurance that one person engages to secure another against an anticipated loss or to prevent him from being indemnified by the legal consequences of an act or forbearance on the part of a party or another third party. And so in my world, generally you see you are indemnifying, seller is indemnifying the buyer for any third-party claims that the buyer catches, and or vice versa. So the question kind of becomes, when would you bring a breach of contract claim versus when would you bring a claim for indemnification and restitution for third-party? And mostly it has to do with, privity of contract, right? If a third party brings a claim against the owner of the property, for instance, I'm the buyer, I'm in my inspection period, and I send out my geologist to go do soil reports, and they dig a big old hole or someone gets hurt on the property, for instance, and that contractor sues the owner because they own the property, even though they were sent by the buyer. And so in that instance, right, the buyer should be indemnifying the owner for any claims that they catch because of the buyer's representatives that were on the property. So typically instances where you would prefer bringing an indemnification claim over a breach of contract would be times where the remedies for indemnification would be greater. So a lot of times in contracts for a breach of contract claim, those remedies are limited, maybe a monetary amount, seller can't be held liable for more than the purchase price, or sometimes it'll be a percentage of the purchase price that limitation is set at. Other times you see a floor on when you can bring a claim, a breach of contract claim. So you can't bring a claim against me until your damages exceed $100,000. And so that's something important to look for and determine which route you want to take, if there's a claim to be had. And then also you want to be mindful of the state's statute of limitations and or survival periods on indemnification versus breach of contract claims. So in Texas, there's a 4-year statute of limitations on breach of contract claims, under which you have to operate. So here's a sample clause. So it says, from and after the effective date, so there's no outside date, indemnitor will indemnify, defend, and hold harmless all indemnified persons from and against any and all indemnified liabilities, including indemnified liabilities caused by the ordinary negligence of the indemnified person, but excluding liabilities to the extent caused by the gross negligence or willful misconduct of the indemnified party. So the main thing to be aware of is this duty to, you have indemnify, defend, and hold harmless. And so a party's duty to indemnify is separate and distinct from the duty to defend. So if you are the indemnitor, if you're the person that's going to be liable for any claims, you want to limit this provision to only indemnification. I will indemnify you for this, that, and the other. By throwing in the duty to defend, that ultimately creates the duty to defend before any actual losses are even suffered. So if a third party brings a claim, my contractor slipped and fell and they sue the seller. Well, the seller can go out immediately and hire an attorney and start racking up legal fees. And if I have the duty to not only indemnify, but also defend the seller, then I would start being liable for those attorney's fees as well, even if ultimately there is no final judgment brought against the seller. So that's one drafting tip to be really aware of. And then hold harmless, that is a contractual arrangement whereby one party takes on all of the liability and basically relieves the other party of any responsibility. So again, those 3 words, although we see them together all the time, do mean something very different. So definitely something to be mindful of. So here, just breaking down some negotiable provisions that you'll see with respect to indemnification. You have the time period. So as I said, and that example is set as of the effective date. Maybe it's only during the contract period, and after the contract period, it doesn't count. Or maybe it's only during the inspection period. You'll indemnify me for anything that happens, or something like that. So something to be aware of. Also, frequently, I will get a contract from another party, and it just causes my client to indemnify them. So a practice tip, I'll just go ahead and make it mutual. If I have to indemnify you for anything that my employees do, then you also have to indemnify me for anything your employees do if I catch a claim by reason of being part of this contract. Parties that are covered, so right, it would, in my, in transactional world, it's the seller and the purchaser. Also, sometimes, I would have to indemnify your employees, your agents, your representatives, your owners, your directors, sometimes even invitees or licensees. So, if my friend comes onto the property and causes you a loss, I would have to indemnify you for their actions as well. And then we move into covered losses. So this can be something where you really want to be aware of how broad of the scope is of this indemnification provision. and really make sure if your client is the indemnifying party that you limit this as much as possible. So sometimes you'll see, I'll indemnify you for losses caused by your actions versus relating to your actions, or maybe with respect to or in connection with your actions. And so if you really dig deep into what those words mean, you can see that, if it's directly caused by my actions, that is far more narrow of a scope of things that I would be liable for, versus if it's just related to something I did, that could be some sort of domino effect that you want to be careful of. And then again, with losses, a lot of times you'll want to define that, make it a defined term. So it's losses, costs, expense, damages, injuries, liabilities, penalties, throw in the kitchen sink, because that way, you understand what a loss really is. And same with claims. Claims could be accusations, litigation, petitions, demands, a subpoena, anything like that. And so you want to understand what is a loss and what is a claim. So with claims, you could have actual or prospective claims. So if I have to indemnify you for a prospective claim, again, that means someone sends you a notice and I'm automatically on the hook, versus an actual claim that is, comes to litigation and is actually litigated to a final determination. So direct or indirect are also important words. If you are the indemnity, you want to say indirect as well, because again, that broadens the scope. And then again, in the example you saw, most of the times it will include anything for the indemnitor's negligence, but exclude any gross negligence, willful misconduct, or fraud. So they can't get away with, just being a bad actor. And then finally, insurance coverage. You want to always advise your client to look at their insurance coverage. A lot of times professional liability policies will carve out any contractual claims, which would include the duty to defend. So again, make sure your client is talking to their insurance provider and making sure that, if they can, if it's not too expensive, to not have those sorts of provisions excluded.
Yep, and I'm gonna do two things. One, just tie back to the reps and warranties piece and indemnity. One other point to make, and most of the time in the M&A context, the seller will insist that and it's market standard to insist that the reps and that the indemnity provision is the sole and exclusive remedy for breaches of reps, and so the breach of contract claim is actually kind of merged into the indemnification, and it's the only way you can recover absent usually some kind of fraud. And probably beyond the scope of this, but defining fraud is something you want to think carefully about if you're a seller, to try to limit that as broadly as possible, so to limit it as much as possible, so you don't have a backdoor that a buyer can go and make all kinds of kind of constructive fraud claims. And we had a request to read the CLE number again, just in case you didn't catch it at the beginning. So the number you need is 174-085-773. So that's 174-085-773. Katherine?
Okay. So then kind of switching topics here, we're going to look more at commercial agreements. So your sales of goods, sales of services. What should you consider when you are negotiating an agreement like this? I can tell you on the legal side, a lot of times this is something that you're going to have to work directly with your client, because you may not always know it. Even in-house, I don't always know the answers to all these questions. And these risks are not always something that I can quantify without that help. So while, Ashley and I are going to go over some of the things that you need to consider, do be aware that you're not probably going to know the answer to every single question, but it's something that you need to bring up with everyone involved before you finalize an agreement. So hopefully you remember a little of this from law school, but sort of the basics of your deal that you obviously need to have and need to define clearly are what are you buying, or or what are you selling? What is this contract specifically about? If you're vague on this, it can affect your warranties, your payment terms, and other parts of your relationship. So clearly defining what goods or what services you're buying or selling is important. Obviously, how much do those goods or services cost is a key point of that deal. And then when are services performed or goods delivered is something that is not always as well defined. So you may have a firm fixed price for your goods or your services, but you may not know how many goods you're going to sell, or when the performance of the services is going to happen, or if it's going to happen multiple times. A lot of times I find that goods contracts between companies will be requirements contracts. So rather than saying, I need 20 widgets for this price, you would say, well, for the next 3 years, I'm going to buy all of my widgets from you, seller. And I'm not going to define what that is yet. I may define that later. It may be at multiple times, but for the next 3 years, I'm not going to go anywhere else. You may also have something called indefinite delivery, indefinite quantity. And what that means is I have no idea how much I want to buy. I have no idea when I want to buy it, but I do know how much it's going to cost. So when I do something like that, I may need to promise a minimum buy or a minimum dollar amount, but it also is a set period of time in which you may not strictly define when you're having services performed or when you're having those goods delivered. So then the next thing you look at with any commercial contract is your term and termination. I think really with any contract you're going to do, these are important things to think about. So as I mentioned, the performance of a contract is not always clearly defined. So if you don't know, this is just that I'm selling you 20 widgets and you're buying them and then the contract is over, you may need to look at how long is the contract. Is it just one transaction? Is it multiple transactions that you need to define the quantity of goods or services and the date they will be delivered? If you don't know that, you need to specify a period of performance in which any number of goods or services may be ordered. What your consideration for things like that is going to depend on the terms you set up, but it is very important to be clear as to how long that agreement lasts. So for instance, as I described the requirements contract earlier, if you define it for 3 years, you want to make sure that you understand when that contract ends so that in 3.5 years, you can go somewhere else to buy goods. You're not bound any longer by that contract. Termination provisions are often hotly negotiated in commercial contracts. I find who should be able to terminate a contract and for what reason? Do you want unilateral termination, a multilateral termination, or no termination at all? And do you have something, do you want to have termination just for default in the contract or for convenience? So for mutual termination, either party can terminate, and these are common, but depending on if you're the buyer or the seller, it may not be something you want. I know a lot of times when I have done supply chain contracts, I would rather not have mutual termination because I generally, as a producer of goods, have another customer that I'm bound to. So for me, getting out of a contract quickly is important. That's why I need that unilateral termination right. But for my supplier, maybe it's not as important. If they have to wait to go through a breach of contract claim and go through a court system, maybe that wait isn't as big of a deal, whereas I'm bound to only buy from them for 3 years. And if I don't get out of this contract quickly, I'm going to breach my contract to my final customer. And then you can also look at things like whether it's termination for default or convenience. So default, a lot of times parties will define what default of a contract is, but they are often pretty broad terms. Generally, if you have an action that can be conceived as a breach of contract, you can usually define it as default that gives rise to a termination for default. But of course, this depends on the language you use. Termination for convenience is a little different, and it's not fully common in all commercial contracts, but it's becoming more and more common. It actually got its start after the Civil War in government contracting, but has been starting to be used more widely in commercial and construction contracting. And it essentially just says that termination can be made for any reason. And people see language like that and they freak out, right? We're entering into this contract. If you can just end the contract whenever you want, then what is the point of this agreement? But courts have found that termination for convenience can't be terminated in bad faith. So a lot of times termination for convenience is used when you are the final producer of an item you're selling to a customer, the customer terminates your contract, you need to be able to terminate your supply chain. Or if you are, and I did a lot of government contracting, so if the government's buying something from me, they lose their funding, I need to be able to terminate my contracts with everyone else helping me. It is becoming more widely used in just general commercial contracting, but it does have really specific kind of court rulings around it that aren't necessarily widely acknowledged or widely known. The next thing you want to look at is options. So options will extend the period of performance or provide for another delivery of goods or for services. They can be either multilateral or unilateral. I always advise that if there's an option, it should be the unilateral right of the buyer. If they want to continue to buy goods, they should be able to make that determination. If a seller doesn't know if they're going to want to have an option later on down the road, then it's probably in the best interest to just wait until you get to that point, rather than having requiring both parties to sit and negotiate and come to a mutual agreement to exercise an option, because in the end, you're just renegotiating a contract anyway. Renewals are very similar, except generally you will just renew a contract for the same term, same amount of time with the same terms. Sometimes you put the language specifically in the contract saying that you'll discuss renewal at a certain time. Sometimes it's just as you're coming up on the end of a contract, you want to keep it going, you have a great relationship. You may just either amend the contract to renew it or sign a new contract with all the same terms to renew that. So then I want to talk about warranties. They may be specified or left up to the warranties available at law. I will say most companies would prefer not to have warranties available at law because they want to specify exactly what they're warranting in the contract. Most commercial contracts will exclude express warranties other than those specified. And if specific warranties are listed, they will probably exclude all of their warranties. So you can limit warranties by a specific period of time, and most commercial contractors will, because they will give, and this is just even if you're going to the store to buy something, right? You have a limited period of warranty in which you may have remedies, and then after that, it's kind of good luck. If you're buying goods with a warranty and you're not the final customer, you may need to understand what warranties you pass on to your customer. So if I'm a manufacturer, I buy from my supply chain, I need to understand the warranty that I give my customer on the final product to ensure I have coverage from all of my suppliers. And then a lot of times warranties will provide a specific remedy. Sometimes this is repair or replacement, return of purchase price, or anything else that may help or may remedy the situation. And here I have just a couple of really common warranties used in commercial contracting. We're getting close to the end of time, so I won't go into details on all of them, but these are the ones you're going to see most often. And if you have questions on them, feel free to reach out. But these are also something, I mean, you can just go search for these online. You don't even have to get on Westlaw or Lexis or anything.
Okay, and then real quick, I would be remiss if I did not mention Professor Anderson at SMU. I know a lot of you have had him. He was my absolute favorite. He teaches sale of goods, he teaches contracts, and I'll never forget the few days that we covered Section 2207 of the UCC, and it was scary, and I feel like most people still don't understand it. But really, when you break it down, it's the battle of the forms, and it's the situation where the, buyer sends in their offer, their seller sends their form of purchase agreement, and then the buyer sends their form of acknowledgement. And a lot of times there's going to be conflicting provisions in those contracts. The parties don't really care. Mostly all they care about are the time and place for delivery, the price, the quantity, things like that. And so basically what 2207 tells us is that if the contract between the Battle of the Forms consists of the matters on which the parties agree, plus the matters that are only included in one party's form and not the other, and then minus any conflicting terms. So that is something that you can utilize for your client if there's an issue between, well, whose form governs or whose form controls. Another provision 2309 just basically says if the contract is silent, then the delivery of goods is due within a reasonable time. Considering what is reasonable given the circumstances. So with COVID, right, a lot of sellers and especially international manufacturers were delayed in their delivery, but was that reasonable given the fact that we had a national or global pandemic with bans on travel and shipping and things like that. And then the last one is just section 1304. It means, each party has an implied duty of good faith and fair dealing. So if your opposing party is acting unfairly, that's something that you can rely on.
And sorry, Ashley, I think I hit a button. I'm not going to get into much detail here, but if you are in a company, you are probably seeing more terms about cybersecurity. I'm sure you all noticed about a year and a half ago when you got a bunch of emails from companies telling you their privacy policy changed. Data security and data privacy are becoming very big for companies. There's sometimes regulatory requirements that require it, and sometimes it's just that's what the customers expect. So you can expect to see more clauses that deal with this, sometimes in your commercial agreement, sometimes in your non-disclosure agreement.
Okay, and then really quickly on boilerplate, I think, a lot of times people just breeze right through the boilerplate at the end of the contract and think, oh, it's all the same, and they all say the same thing, but you need to read the terms and read the terms carefully because there are a lot of snaky attorneys out there that will throw things in the end of the contract in the middle of the boilerplate provisions and it'll get you. So read those terms, read them carefully. Just running through some of the more important ones, assignment. Sometimes you have prohibited assignees or permitted assignees. So if you want to, you'll ultimately assign the contract to an SPE before you close. You want to make sure that the buyer doesn't have consent rights over that it's automatically pre-approved. Limitation on damages, like I mentioned earlier, monetary caps or things like that. Notice provisions, one thing these days, especially if you have, email is an option for notice. Sometimes contracts will say you can send your notice by email, but you also have to send it by one of these, 4 other methods. You need to also overnight it. So that's just something to look out for. And those are things that are negotiated. Sometimes your clients don't want email notice if it's, a guy in his 90s who doesn't know how to use his AOL account. Sometimes you actually want to negotiate the contract to exclude email and or, like I said, make sure that you're also getting notice some other way so it doesn't just go unnoticed. And then force majeure, I've given a full presentation on this. I could say a million things. So I'm not going to go into it. We're running out of time, but it's basically, it can be an out for your client, either if they're prevented or delayed in performance or if they just can't do it at all. And so you want to look at those force majeure provisions very carefully, especially with COVID and government. These have become very important and highly negotiated. So again, it's just a defense to be able to get out of performance. But noteworthy is almost always it does not give your client a get out of jail free card for not paying monetary obligations. So a tenant still has to pay their rent, even if they're prevented from actually, performing their business at the premises or something like that. So again, there are more materials on that, but we do not have time. And so I think I'll just let Bryan touch real quickly on the practical advice and then we will we'll close up.
Yep, sure. So I think we are running a bit short on time. I think our general point, we had a few examples here, which when you look at the slides, you're welcome to look at on emails. But our general point was that we often don't make emails as concise as they should be. And depending on the audience, they may need to be, the primary driver ought to be efficiency. folks don't have time to read a long memo all the time, especially if they're reading on their phone. And so just, I think the thought here is practically be cognizant of who your audience is and really draft toward that person. If you're drafting for something where you really need someone to sit down and they want you to do the analysis, of course, do lengthy analysis, but if not, try to get to the point, and then they can follow up with questions. So I think that we'll skip the examples here for now, and you can take a look at those if you want to later. And I'll say on emails to adverse parties, just think closely about those before you send them. Don't click send too soon. So we really appreciate you joining us, and thanks for your time this afternoon.
Thank you, everybody.
Yeah, and on behalf of DAYL, thanks Ashley, Katherine, and Bryan. We really appreciate it. This concludes our CLE, and look for the slides in the email or in the video on the weekly brief as well. Thanks.